Please,
Yes.
my lord, I beg to mention item number 3 and 4. Here we are yet to file our counter. We are sending it for vetting, so kindly grant us 1 week time.
1 week. Learned counsel for the petitioner, Ms. Tai Krilo is present. Stop. Mr. I. Jamir, learned counsel for the respondent 2. Respondent 2 submits that he would like 1 week's time to file the objection affidavit. Stop. Prayer is allowed. List after 1
May I
week.
please, Your Lordship? Lordship, can it be listed on 23?
23rd?
No objection.
Okay, list on 23. 3. Yes.
Lordship, please.
The interim order passed earlier shall continue till the next date.
Oblige.
May I please, Lordship?
Yes.
Lordship, with respect to item number 5, Lordship, on last occasion I submitted the department has prepared SLP. Lordship, Supreme Court on 23rd of February issue
Yes.
notice in the matter and fixed on 1st of April. May I pray that matter may be taken up to 15th of April, Lordship.
Okay,
Item number
notice
5.
issued. Notice has been issued.
In this case, bail has been granted, Lordship.
Okay. Learned.
May I pray, Your Lordship?
Yes.
Because Your Lordship was pleased to grant me interim bail, Your Lordship. That may be made absolute, and so far as merit part is concerned, that may be decided after.
So, Lordship, we have objection to that. Lordship, may
Continue. Let
yes,
the
Lordship.
continue.
Yes, Lordship.
Learned counsel for the petitioner, Mr. Your name?
I am A. Goyal.
A. Goyal is present. So he learned CGSE submits that the SLP the SLP which has been preferred by the Union of India
Yes, Lordship.
has been admitted, and the impugned order has been stayed, and the
Lordship, no interim order has been passed.
and notice
Issued an
has been
interim order.
issued.
There is no interim.
Okay, and the notice has been issued, and the matter is now fixed for
For a necessary order on 1st of April, Lordship.
on 1st of April 2026. Accordingly, learned CGSE prays that the matter may be listed on 15th. You want
After
it
15, Lordship.
after
After
15th?
15th of April, Lordship.
Okay, Mr. Goyal.
My lord, let it be, my lord, on 21st, my lord.
Okay, 21st
Lordship.
on 21/4/2026. Stop. The interim order passed earlier shall continue till the next date. Yes.
Much of
Deep, Lord.
For motion, item number 1.
May I please, Your Ladyship?
Oh, this is that matter.
Ladyship.
Okay, anyway, what was it? The
Ladyship,
facts?
I may be allowed to make my brief submission,
Yes.
Ladyship.
Yes.
This instant petition is preferred under Section 528 of the BNSS, seeking to quash the FIR dated 11/10/2025 in GR 562 of 2025, registered under the urban police station under Section 409, 420, and 120B of the IPC.
Where is the FIR? Annexure 1.
Ladyship, I have reproduced in my paragraph 3, Lord, Ladyship. The FIR is annexed here in Annexure 1. However, I have reproduced. I may be allowed to read the
Yes, yes.
FIR, though it's a little bit lengthy. I take this page number 4 in my petition. I take this opportunity to lodge this complaint against the following persons who have attached a criminal conspiracy among themselves, and in furtherance of such conspiracy, they have cheated me the sum of rupees 5 crore, thereby causing wrongful loss to me and wrongful gain to themselves. The accused persons are: number 1, Ms. Anil Patoria; 2, Milan A. Shah; 3, Mr. Sandeep Patoria, and the petitioner is number 1, accused number 1. Here does it, accused number 1. Now, the aforesaid accused persons are owners, controllers of a company, namely MS Apcon Properties Private Limited, having a place of business at 4th floor, flat number 22, 105 Park Street, Kolkata. Now, the matter starts from here, Ladyship. On 10/12/2010, Sri Arun Patoria, now he is no more, he's deceased, was introduced to me by Sri Pradeep Agarwal, son of late so-and-so, who has been known to me for many years. The meeting was held at Tahekhu village, Dimapur, Nagaland, which is under the jurisdiction of your PS. Now, Sri Arun Patoria, deceased, represented to me, which representation subsequently transpired to be a false and dishonest, that their business was in a very good financial health, but that he required a long-term cash amount accommodation in the form of a loan in goodwill and promised to pay a profit of 30% on the loan amount. At the relevant time, he malafidely suppressed the true financial health of his companies and sought a loan term of rupees 5 crore only for a period of 4 years. Now, relying upon such assurance, I, Kuhoi Sumi, who is the complainant, the undersigned handed over a rupees 1 crore only in cash on the same day, and I agreed to give a further sum of rupees 4 crore on 17/12/2010. Subsequently, in furtherance of my earlier assurance on 10/12/2010, a sum of rupees 4 crore in cash was given on 17/12/2010, a gap of about 7 days, to me by Mr. Arun Patoria in his office at 105 Park Street, Kolkata, in the presence of Sri Pradeep Agarwal and 3 other directors of Apcont Properties Private Limited, namely accused number 1, 2, 3, respectively, who also assured and promised to repay the same to me in 4 years receipt of money in, which is annexed herewith. Now, around September 2015, I requested the accused to account for and return the sum of rupees 5 crore along with profit, and also immediately sought the intervention of Mr. Pradeep Agarwal. After weeks of persuasion and request, the accused person sought time to clear liability, citing reasons that the father of accused number 1 has recently expired and they thus requested for some time. In and around December 2016, I again requested the accused persons to return the loan to me along with profit, and once again sought the intervention of Sri Pradeep Agarwal. Now, the accused persons collectively assured me that the company project has been sanctioned and that by 2021 the project would be completed. Further, all dues would be cleared. After that, a copy of sanction plan was annexed. Now, in mid of 2022 again, I once again approached the accused persons for repayment of the loan amount along with profit. The accused persons kept delaying the matter with one excuse or another, and by December 2022, it became apparent to me that the accused persons had no intention of paying the sums due to me. I am aware that these accused persons have defrauded many other persons in this manner. They are a threat to society and commerce. A thorough investigation is thus required to unearth the nature and extent of the criminal conspiracy hatched by them. I am a private resident and I have no resources to gather the necessary evidence to prosecute the accused persons. Meanwhile, their interrogation is promptly required to quash and modus operandi of their illegal activities. The last paragraph, the false and dishonest inducements were met at Tahekhu village, Dimapur, Nagaland, in which is situated under the area of your police station, and therefore I request you to kindly treat this as a first information report and investigate the matter. Now here, Ladyship, if I may bring to the notice of this court that as per the complaint letter, the transaction was done on 2010. Now the FIR was lodged in the year 2023. 7th of January 2023. Lordship, after a span of 13 years, they are coming to address this issue. Now, subsequently, the complaint letter, the first complaint letter was kept on hold with the, as mentioned in the complaint, that they have a conversation. But let me clarify this, that the petitioner have never ever met this complainant in person until they were brought in the police station Dimapur, arrested from Delhi in the suburban police station Dimapur on 22/11/2025, Ladyship. Now, even if otherwise, assuming but not admitting, even if all the transaction has been taken place, the FIR the FIR, as we assumed the FIR dated 7/1/2023 filed by the complainant, the ingredients, the statutory ingredients are not met out. Number one, offer and acceptance if there be any, or lawful consideration, or capacity to contract, nothing has been met out. And very interestingly, in the complaint letter 7/1/2023, time and again, it was in the presence of Mr. Pradeep Agarwal, who is actually not being arrested so far, actually, flying in the air so far. And so
He is also named as accused. This
no
Pradeep Agarwal.
leadership. In fact, perhaps they are hand in glove with the complainant, and that's the reason why he is not being arrested so far. Now, in the complaint letter itself, as we go through, there is no way presence of the accused. There is no way presence of the accused in the first transaction, perhaps. Later only, in the verbal complaint only, it has mentioned that in the presence of accused number 1, 2, and 3 at Kolkata, 4 crore was being handed over. That's what, but nowhere, no documents is substantiating to the complaint. Now, ladyship, this complaint letter, and if I may take you to my petition annexure.
We'll issue notice at this stage, but
Ladyship,
what
I have-
stage is it? Investigation still going on?
Investigation going on, but ladyship.
Are you cooperating with the
Ladyship,
investigating agency?
ladyship. If I may bring if I may be allowed to produce one of the record, ladyship. This I have not annexed it because the investigation is still going on, but the dates and the modus operandi, how the complainant is trying to make it into a criminal color when it is purely a civil dispute, ladyship. If at all, assuming but not admitting that 4-5 crore was handed over, and in nowhere the man, Mr. Arun Patoria is no more actually, and trying to falsely implicate the petitioners. Ladyship, this is the sequence of the notice 94 and 35 have been issued by the investigation agency. Now, very interestingly, ladyship, if I may bring to your notice, number one, APCON properties. As per the complaint, the agreement was entered with the APCON properties, but undue harassment has been given to the petitioners, bringing all the other companies that they are involved. And not only that, but the 94 and section 35 of the BNSS was issued even when they were in custody, knowing the fact that the alleged accused, the petitioners were in custody. Still the investigation agency has gone beyond exercising their power of issuing the 94 and 35 of the BNSS when they were in custody. On 28/11/2025, 8/12/2025, they were released only on 15th. But they have exercised.
All three of them?
No, two of them. Accused number 1 and 3. Accused number 1 and 3. And the accused number 1 is here before this court this morning. And so they were unnecessarily harassed, ladyship. Now, one again very important issue that I may be allowed to bring to the notice of this court, that as per the investigation report, this is that the accused were not cooperating. Section 35B3 was issued on date 14/10/2025. The alleged accused have never ever received this notice. In fact, as per the statements, it was Mr. Pradeep Agarwal who has received on behalf of the petitioners.
See, interestingly, the other day,
Ladyship.
this accused number 2 had also filed
Ladyship.
a criminal petition.
Ladyship.
And he has stated in his petition that he does not know anything about the matter, and
Ladyship.
that it was only this present petitioner who is the main accused.
Who is the main accused?
Yes.
The petitioner's
Okay.
brother, ladyship,
So-
the who is no more, who has entered into the contract or whatever the
Anyway,
transaction.
we'll see.
Ladyship,
Yes.
if I may, just 5 minutes, ladyship.
Yes.
This section 409, 420, and 120p, nothing has been met out, ladyship. Nothing.
that
no
is
offenses.
not for this court to
Ladyship.
think.
So my
We'll
only
see.
humble submission, ladyship, if I may be, I have my interim prayer, ladyship. I have my interim prayer. If
You are now on bail.
ladyship,
You are on bail.
if I may, yes, I'm on bail. As per the bail order also, ladyship, if I may read out page number 62. That's my typed copy. The original copy is not very clear, but in my petition, even the observation of the Honorable C. James Court has observed.
Page
and
62.
62 of my petition. It is a typed copy of the order dated 12/12/2025. The last paragraph, if I may be allowed to read. On perusal of record, it is seen that two accused persons, Ms. Anil Padoria and Sandeep Padoria, were arrested on 21/11/2025 on the strength of NBWA issued by this court. Another accused, Milian A. Shah, could not be apprehended and NBWA against him returned unexecuted. On perusal of the record, it is seen that the instant case relates to written complaint lodged by one Shri Kohoi Sumi of Daheku, Dimapur against the aforementioned three accused persons. It is alleged that the accused persons, through their company, namely Account, investments from the complainant with promise of high returns and committed alleged offences of cheating, criminal breach of trust, and criminal conspiracy. As per the case status report received from the IO of the case, except for averments that release of the accused persons will adversely affect the investigation. There are no cogent materials placed on record warranting further judicial remand of the accused persons. So that was the observation and being
No, that is different.
Ladyship.
No cogent material to keep you in custody. This is for the custody.
Ladyship, what I'm trying to say is that as per my annexure, even complaint later and annexure 29. These are the only two materials that the complainant is relying and making this civil dispute into a criminal in nature, ladyship. The type copy is at 111, page 111. This is the only document that they are relying. If I may be allowed to read, ladyship. Page number 111, annexure 29, type copy. 17/12/2010. Received a sum of rupees 1 crore in cash on 10/12/2010 at Dimapur and an amount of rupees 4 crore in cash on 17/12/2010 at Calcutta from Kohoi Sumi in presence of Pradeep Agarwal. There's no way written mention about the names of the petitioners. A total amount of 5 crore cash with profit of 30% shall be positively returned within a period of 4 years, not later than 10/12/2014. Witness was Pradeep Agarwal again. So in the presence of Pradeep Agarwal, there's no mention of this petitioners and unnecessarily harassing. And not only that, ladyship, on 21/11/2025, as they were in Delhi, they were apprehended there, kept for about 2.5 hours and arrested from there and brought straight to Dimapur. No production was happened. They were straight brought to Dimapur and they were sent to
Okay,
judicial
Chelsea.
custody.
Yes.
And for 24 days they were in
Right.
custody. Ladyship.
The present application under Section 528 BNSS has been filed by the petitioner, praying for quashing the impugned FIR dated 11/10/2025, along with all the consequential criminal proceedings in connection with GR 562/2025 in Dimapur Suburban PS case number 56 of 2025 under Section 409, 420 and 120B IPC. Stop. Heard Learned Counsel, heard Learned Counsel for the petitioner, Ms. Apila Sanctum. Also heard Mr. B. Jimomi, Learned Public Prosecutor for the State of Nagaland. Stop. Para. The main, the case of the petitioner is that the cause of action arose on 17/12/2010, whereas the FIR in the present case was lodged only on 11/10/2025. Stop. In between, the complainant had also submitted a complaint letter dated 7/1/2023 and 18/8/2025. So, however, the formal FIR was lodged only on 11/10/2025. So, hence, the petitioner has submitted that there is an unexplained delay, long delay of 10 years. 10 years?
13 years,
13
if you have
years.
to count the first
13
complaint.
years in lodging the FIR, and hence the same is illegal and could not have been registered. Stop. Another submission, another contention of the learned counsel for the petitioner is that in the letter dated agreement, is it an agreement, this 1712? In the agreement dated 17/12/2010, basing on which the FIR has been lodged.
Ladyship, if I may be allowed, it's
Yes.
not agreement also, it's just a receipt copy.
Okay,
Yes,
the
Ladyship.
receipt dated 17/12/2010, on the basis of which the FIR has been lodged, comma, none of the accused persons, the presence of the present petitioner is not shown, and that it is only one Mr. Pradeep Agarwal who has been shown to be present at the time when the alleged amount of rupees 5 crore, is it 5 crore?
Ladyship, 1 crore at one and 4 at the second.
5 crore was handed over to the deceased Mr. Arun Kumar Potoria, Phutoria. Stop. The learned counsel therefore submits that the ingredients of section 409, 420 and 120 BIPC are not present in this case, in the instant case. Stop. Issue notice returnable in 4 weeks.
Ladyship, my
Yes.
interim may be considered, Ladyship, until the next returnable date. Otherwise, irreparable damage is being done.
See, the investigation is still on, and now that you're on bail, there is no question of them.
If my
yeah.
bill may be accepted, that notice.
We'll see on the
94
next date. We'll see. Let them produce
Ladyship,
the
if that
records.
may be a short date, because the amount of damage being done is irreparable, and this is a
What
purely
sort
an-
of damage?
because they are outside,
You're on
of
bail and now
outside of
yes.
state, but 94 and the 35 is being sent in time and again, and we've been replying, but parents is being called time and again, ladyship. And not only in ACON, the agreement must be the ACON, but the
investigation
other
is at initial stage, Lordship. Let the
ladyship,
investigation
but
go. In the meantime,
the agreement
they
is
are on protection, Lordship.
clearly shown that it is ACON, but the other
No, if
other-
necessary, the IO can examine you online also, through VC
Ladyship,
also.
if that may be reflected, that will be grateful, ladyship. Virtual maybe.
What did I say last line? Issue notice returnable in 4 weeks. Where are they staying? Delhi?
Calcutta, Lord, ladyship. Or in that case, ladyship, my humble submission, even if not the interim, but if until the next returnable date, no notice may be issued, ladyship.
No, that we cannot say. The petitioner shall also take steps for notice on the complainant respondent. Number two, by speed post as well as usual process within 3 working days.
Ladyship.
Stop. The public prosecutor shall produce the updated case diary on the next date, and the interim prayer shall be considered on the next date.
On the next section.
Ladyship, if our presence may be dispensed.
And till before the next returnable date, if the petitioner needs to be examined, the IO shall do the same through VC if necessary.
Ladyship, that will be great. Ladyship, I also.
But you have to supply your email in that case.
It's already done, it's
Already
already
there.
supplied, and the documents are being already furnished, ladyship.
Please stop your 4 weeks.
Ladyship, if I may be about to mention, in the last on date 6/3/2026, I put up 2 petition number 1 and 2. However, the order has been withdrawal with liberty to file afresh. That's been reflected only for criminal 5 of 2026, and that is how the petitioner is before this court this morning. Now, for criminal petition 6 of 2026, the withdrawal order has not been reflected in the e-court, ladyship, and that is how I was unable to file it, ladyship. So, if the withdrawal may be permitted with liberty to file afresh.
But that matter is not here, not today.
No, ladyship. We
Which
were not
one?
able to file
Criminal
subsequently.
revision 10.
Criminal petition 6 of 2026.
6 of 2020.
This is the same matter, ladyship. Same matter.
It should have been reflected in that other case also, actually. What we can do is, you just send the file to me, and then I'll dictate to the stand. No?
Ladyship, that is the same matter. So if both accused 1 and 2, petitioner 1 and 2, that
No,
was
no, but the other one, you have not filed the amended petition, no?
we have already amended petition with the
Already
paragraphs-
filed?
Yes, Ladyship, but it was not listed, considering the fact that it was not reflected in the e-court.
Acha, acha,
And so we were not able to produce the order. However, I have filed the petition.
Okay,
So
okay.
it is same matter. They were arrested together. They were put on the custody for 24 days without no reason, and they were released on 15/12/2025.
Okay, you just give the mention memo and then we will do the needful.
Ladyship, grateful ladyship.
For admission, item number 2.
What we'll do is we'll have to pass another order in that, then only it will be listed, no? Yeah. Yes,
May I please, Lordship?
what is this for today?
This is an MSc meter, yes, Your
Admission.
Lordship.
MSc, Lordship.
Records have come. We'll list it for hearing then.
Matter is very small, Your Lordship.
You're ready?
And it is 2000, lingering since 2014,
Okay,
Your
okay.
Lordship. And
Yes.
If I may, Lordship. Lordship, this instant make appeal is filed to set aside the judgment and order dated 09/12/2024. Passed in MSc case number 77 of 2014, Lordship. Your Lordship, the brief fact of the case is that the respondent number 1, as claimant filed a claim petition under section 166 of the MV Act 1988 before the Motor Vehicle Accident Claim Tribunal, Dimapur, Nagaland, been registered as MSc case number 77 of 2014, claiming compensation on account of the injuries sustained by him in an alleged road accident on 06/01/2013, involving one motorcycle bearing registration number so-and-so, driven in a rash and negligence manner, knocked down the claimant. As a result, the claimant suffered grievous injuries. In the said claim petition, the applicant was implicated as opposite party number 1 by the claimant respondent, Lordship. Your Lordship, before I go through the grounds of appeal, let me just highlight some of the important facts of the case, Lordship. In my priority, Lordship, that by judgment and order dated 27/07/2017, the MSc case number 77 of 2014 was disposed of with the direction to the insurance company to deposit a final award of rupees 5,33,920 within 30 days from the date of this order, Lordship. Thereafter, the present appellant has filed an appeal before the Honorable Gauhati High Court Kohima bench, which was filed and registered at MSc Appeal number 8 of 2017. And by order dated 27/07/2018, the Honorable High Court set aside the impugned judgment and order dated 27/07/2017 passed in MSc case number 77 of 2014. And the case was remanded back to the learned tribunal MSc Dimapur, who shall trial the matter afresh after the respondent number 1 claimant has been examined. So if I may, Lordship, may kindly come to
Earlier it was disposed of without examining the claimant.
the, yes, if I may take you to the relevant portion, Lordship. Page 19, Lordship. The Honorable High Court Order 27/09/2018, Lordship.
Page 19.
Page 19. Annexure A2.
Yes.
Lordship, the type copy is at page 20A. The type copy, 20A. So if I may take your Lordship to the relevant portion, Lordship. Page 20B, paragraph 4, Lordship.
Yes.
Lordship, on perusing the record of the learned tribunal Dimapur and MSc case number 77 of 2014, I find that there is no permanent disability certificate issued by the medical doctor. The finding of the learned tribunal that the respondent number 1 claimant sustained 40% disability has been met on the basis of the averment made by the respondent number 1. However, as stated above, there is no report made by any medical doctor in the record stating that the respondent number 1 has sustained 40% permanent disability. Further, no medical doctor was examined by the learned tribunal. On this ground alone, this court is of the view that the learned tribunal earned in averting the compensation for the alleged loss of income to the respondent number 1 claimant, as the learned tribunal could not have proved the degree of disability suffered by the claimant. The respondent number 1 will have to prove that he has permanent disability of 40% and not merely 40% disability, Lordship. Paragraph 5, Lordship. In view of the facts stated above, the compensation awarded to the claimant respondent number 1 cannot be said to be proved or supported by the records. Accordingly, the impugned judgment dated 27/07/2017, passed in MSC case number 77 of 14, is hereby set aside. The case is remanded back to the learned tribunal Dimapur, who shall try the matter afresh after the respondent 1 claimant is examined, Lordship. Now, Lordship, the matter was disposed of by this honorable court order dated. But however, Lordship, the tribunal has failed to follow the direction of this honorable High Court, Lordship. Regarding that, I will come back to that in my grounds of appeal, Lordship, in detail, Lordship. So, if Lordship may...
So after that, was the doctor examined?
No, Lordship. The doctor was not examined, Lordship. If the Lordship may kindly, in my grounds of appeal, paragraph 4, Lordship, paragraph 4, Lordship.
Paragraph 4.
Paragraph 4, in my grounds of page number 7, Lordship.
Yes.
For, if I may, Lordship. For that, the learned member in the instant case being remanded by this honorable court was due to the dispute in regard to the consideration of 40% disability upon the claimant without properly examining as per relevant procedure of the law. However, the tribunal failed to follow the direction of this High Court but acted against in anger by delivering with more disability and enhanced award amount, which is a contempt of court to this honorable High Court, Lordship. We also have observed from the claim filed that the admission of disability certificate was not as per the provision of the law. The same was issued by a random doctor, Lordship, and not by a district medical board, nor by the treating doctor who is specialized with the relevant illness, Lordship. Furthermore, that the claimant is a mechanic, then to what proportion to the nature injuries caused to him should be examined, Lordship. Her Lordship, no doctor was examined by the tribunal to ascertain the claimant has really suffered from 40% disability, Lordship. If I may, Lordship, in supporting my...
No. First, let us see the judgment, the impugned judgment, that particular issue.
Page 27, Lordship.
Page
27, Lordship.
27.
Relevant portion is page 32, Lordship. Page 32. Issue number 2, whether the claimant sustained permanent disability as per the provision of section 142 of the Motor Vehicle Act. Lordship, here no doctor was examined by the learned tribunal, Lordship.
Yes.
If I may, Lordship, supplementing to that, if I may allow to supplement. If I may, Lordship, 2001, 1 GLD 393, National Insurance Company Limited versus Chantiswar Thakur, Lordship. If I may, the next page, Lordship. Para 2. The whole contention of the appellant is that the learned tribunal arrived at conclusion that the claimant suffered permanent disability without examining the doctor. Since the claimant sustained injury, it was incumbent on the part of the claimant to have examined the doctor and establish its case as to what percentage of permanent disability was suffered by the claimant. It would clearly appear that besides submitting a certificate from the doctor, no doctor who has treated the claimant has been examined by the claimant. Non-examination of the doctor to establish the extent of disability suffered by the claimant denied the opportunity to the insurance company to cross-examine the doctor, Lordship. In our jurisprudence, witnesses put up by either of the party is subject to cross-examination so as to test veracity or the truthness or correctness of the statement of the witnesses. In the instant case, no doctor has been examined to establish the extent of disability suffered by the claimant, and in that view, the permanent disability has not been proved. Apart from that, tribunal settled the liability with the insurance company on the compensation assessed on the basis of permanent disability suffered by the claimant, without giving any opportunity of cross-examination, cross-examining the doctor. Para 3. In the result, the impugned judgment and order dated 14/10/1999 passed by the tribunal in MSC case number 84 of 1998 is hereby set aside. The case is remanded to the tribunal to start the proceeding afresh from the stage of examination of doctor. Needless to say that the insurance company would be entitled to cross-examine the doctor. With the aforesaid direction, this appeal is disposed of. If I may submit another citation. 2010 2 GLT 176. Oriental Insurance Company Limited versus Laliam Swami and another. If I may take your lordship to the relevant para 10. Para 10, lordship. The learned counsel for the appellant pointed out that the learned tribunal relied on the disability certificate to conclude claimant permanent disability of 55% without examining the doctor who had evaluated and issued the certificate of the disability to the claimant. Learned counsel further contended that the certificate purported to be issued by the medical board of Champai board, the signature of the doctor working in civil hospital Aizol. 11, para 11, lordship. As a matter of fact, its assessment of percentage of disability of an injured a medical expert in the field play a crucial role. On the basis of such assessment, a tribunal embarked on evaluating the loss of earning capacity triggered by disability of the claimant. The degree of disability and loss of earning capacity are not synonymous. Loss of earning capacity cannot be assessed by resorting to mere guesswork. The tribunal should, for all practical purposes, take assistance of a qualified medical practitioner to assess the extent of permanent disability of the claimant. On the other hand, non-examination of the doctor as a witness who gave the certificate of disability will drive the insurance company to test the veracity and or of the truthfulness of the statement and correctness of the documents placed on record by the claimant before the tribunal. The tribunal required to assess the loss of earning capacity, keeping in view the percentage of disability suffered by the claimant. Therefore, the assessment and the evaluation of the injury of the claimant is of paramount significance in proper adjudication of the claim petition. In support of its contention, the learned counsel for the appellant has relied on the division bench of this court reported in 2000. Chandra, this is the citation which I have just read it out earlier, lordship.
Yes.
Para 12, lordship. From the above discussion, it is apparent that the evidence of medical witness is essential for assessment of the percentage of disability sustained by the injured to enable the tribunal to adjudicate the claim. However, in the instant case, the certificate of disability was relied on by the learned tribunal without examining the doctor who has issued the certificate. In the circumstances discussed above, this court is of the considered view that the requirement of all procedure was not adequately followed by the learned tribunal before passing the award, thus warranting remand of the proceeding for fresh disposal in accordance with law. Para 15, Lordship. Without lingering with the discussion any further and without tendering any view and or decision on all such issues raised by the learned counsel for the appellant, in the circumstances discussed above, I hereby set aside the impugned award dated 09/10/2008, passed by the learned tribunal, and remand the case to the tribunal with the direction to start the proceeding afresh from the state of examination of doctor by giving both parties opportunity to adduce additional evidence. If any, the learned tribunal may also summon the doctor who evaluate the injury of the claimant and or issue the certificate of disability to the claimant. And in the absence, the said doctor may examine or any other qualified medical practitioner to evaluate the disability suffered by the claimant. Needless to say that the insurance company would be entitled to cross-examine the doctor summoned as witness by the learned tribunal. However, as the reward has been set aside on technical ground and the entire proceeding has been remanded for retrial in accordance with law, the appellant insurance company may take up all other questions of law-related issue, etc., if any, based on facts before the learned tribunal. I have consciously avoided discussing the merit of the appeal and or the credibility or otherwise of the evidence adduced by the prosecution in the tribunal, so as to enable the learned court below to remain absolutely free to come into its own independent finding. With the above direction, this appeal stands disposed. Your Lordship,
Yes.
Your Lordship, in both the case, no doctor was examined by the tribunal, which is one of the most vital aspects to ascertain the permanent disability. And in this present case also, no doctor was examined by the tribunal, Lordship. So on that ground itself, Lordship, the judgment dated...
Yes. Yes. What happened? The tribunal did not understand the directions of this court.
My lord,
What happened?
my lord.
Because
This-
it is very clear, the judgment of this
Yes,
court,
yes,
it's
Your
very
Lordship.
clear
I'm coming to that.
no medical doctor was examined.
I'm coming to that, Your Lordship. Earlier, no disability certificate was furnished. Then this claimant, while the matter was remanded back, then claimant went there and he obtained one disability certificate issued by a board, 4 doctors. And basing upon that, now Your Lordship will appreciate that this is a beneficial legislation. And in beneficial legislation...
No, see, Mr. Paul, it's
Yes.
like this. Percentage of disability is one matter.
Yes, Your Lordship.
Loss of earning is another matter.
Yes, Your Lordship.
But the court has not calculated and the doctors were not examined. We will have to send this back.
Your Lordship, doctor...
How can the tribunal calculate the loss of earning just saying that 40% disability?
Now,
This is not
disability
done.
certificate is there, Your Lordship.
That is different.
Disability
That
certificate
judgment-
is given by the board.
Judgment is there, Raj Kumar versus Ajay Kumar, I think, where it specifically states that disability percentage may be 50%, but loss of earning is not 50%.
Now,
Okay.
Your Lordship
That
will
is
appreciate
different.
that.
That has to be calculated again.
Your Lordship will
separately.
appreciate that in a number of cases, Your Lordship, this Honorable Apex Court, my learned friend has given all this
Acha, 1 minute.
judgment of this
Any
court.
other submission?
Raj Kumar versus Ajay Kumar.
Ajay Kumar, Okay, just give.
Starting from para 10, Lordship.
Yes.
Para 10. If I may, Lordship. Where the claimant suffer a permanent disability as a result of injuries, the assessment of compensation under the head of loss of future earning will depend upon the effect and impact of such permanent disability on his earning capacity. The tribunal should not mechanically apply the percentage of permanent disability as the percentage of economic loss or loss of earning capacity. In the most of the case, the percentage of economic loss, that is the percentage of loss of earning capacity arising from a permanent disability, will be different from the percentage of permanent disability. Some tribunals wrongly assume that in all cases, a particular extent percentage of permanent disability will result in a corresponding loss of earning capacity, and consequently, if the evidence produced show 45% as a permanent disability, will hold that there is 45% loss of future earning capacity. In most of the cases, equating the extent percentage of loss of earning capacity of the extent percentage of permanent disability will result in the award or either too low or too high a compensation. Para 11 Lordship. What requires to be assessed by the tribunal is the effect of the permanent disability on the earning capacity of the injured. And after assessing the loss of earning capacity in terms of a percentage of the income, it has been qualified in terms of money to arrive at future loss or earning by applying the standard multiplier method used to determine loss of dependency. We may, however, note that in some cases, on appreciation of evidence and assessment, the tribunal may find that the percentage of loss of earning capacity as a result of the permanent disability is approximately the same as the percentage of permanent disability, in which case, of course, the tribunal will adopt the set percentage for determination of compensation. The decision of the Apex Court in Arvind Kumar Mishra versus the India Insurance Co. Limited and Yadav Kumar versus National Insurance Kumar Limited Lordship. Para 12 Lordship. Therefore, the tribunal has to first decide whether there is any permanent disability, and if so, the extent of such permanent disability. This means that the tribunal should consider and decide with reference to the evidence, Lordship. 1 Lordship. Whether the disablement is permanent or temporary. 2 Lordship. If the disablement is permanent, whether it is permanent total disablement or permanent partial disablement. 3 Lordship. If the disablement percentage is expressed with reference to any specific limb, then the effect of such disablement of the limb on the functioning of the entire body, that is, the permanent disability suffered by the person. If the tribunal concludes that there is no permanent disability, then there is no question of proceeding further and determining the loss of future earning capacity. But if the tribunal concludes that there is permanent disability, then it will be proceeded to ascertain its extent. After the tribunal ascertains the actual extent of permanent disabilities of the claimant, based on the medical evidence, it has to determine whether such permanent disability was affected or will affect his future earning. Lordship. Your Lordship, in this present case, they have not proved that the claimant has suffered from permanent disability, Lordship. And
No, this is exactly what I'm saying.
yes, Lordship.
That earning capacity is a different thing, percentage is percentage of disability is a different thing. Done? Yes, what else?
If I may, Lordship, para 5, Lordship.
Para 5 of this judgment.
No, my makeup here.
Your. Yes. Yes, for that.
For that, the learned tribunal failed to consider, despite a lot delay was caused due to appeals, suspension, remand, etc. Happened in the present case, the tribunal failed to consider the direction of this Honorable High Court and wrongly assessed the award amount as well as imposed unfair award interested upon those periods which was not justified. Furthermore, in such circumstances, it was unfair on the part of the tribunal to revert back to the previous date of filing to impose interest liability excessively at 7.5%, Lordship. Para 6, Lordship. For that, the learned tribunal failed to consider the Supreme Court judgment on the interest exemption during the pandemic loan moratorium is in civil original jurisdiction with petition number 476 of 2020. The judgment was delivered on 30 March 23, 2021 by a bench of Justice so-and-so, but the tribunal failed to consider and set interest exemption despite which delay was caused by the claimant during the process of the case, Lordship. Para 7, Lordship. For that, the judgment which was delivered by the present tribunal of Dimapur has no proper speaking order in accordance with the direction given by the Apex Court as held in IOCL versus Nayan Das by Russia. It is observed that in the entire judgment, no proper reference or relevant citation of the Apex Court was referred. Moreover, the tribunal in its judgment has not discussed any evidence brought in the cross-examination nor the law points submitted with relevant case law. Thereby, such judgment should be challenged, Lordship. So, my humble prayer to this honorable court is that on that ground, the judgment and order 09/12 of 2024 may be set aside, Lordship.
Okay, yes.
May it please your lordship. My lord, I beg to take your lordship to this earlier order of this honorable court, page 20.
Yes.
Para 4. On perusing the records of the Learned Tribunal Dimapur MSC case number 77/2014 find that there is no permanent disability certificate. There is no permanent disability certificate issued by any medical doctor. The findings of the Learned Tribunal that the respondent number 1 claimant sustained 40% disability as has been made on the basis of the averments made by the respondent number 1 and on the basis of the medical record submitted by the respondent number 1. However, as stated above, there is no report made by the medical doctor in the records stating that the respondent number 1 had sustained 40% permanent disability. Now, on that point, your lordship, I beg to take your lordship the order of this honorable court, your lordship, as well as the honorable, citing the honorable apex court order. This honorable court has, in the case of this Binita Ghosh, just recently passed by this honorable court, wherein please observe that since it is a beneficial legislation, your lordship, that is why not like other regular cases, evidence should not be taken on that point of view, your lordship. Now, your lordship, wait a minute. Sunita Ghosh. What? Sunita Ghosh, what are you? Anyway, your lordship, they have come with 4 or 5 grounds. Now, grounds wise, I am giving the reply, your lordship.
But this is the main ground they are pressing
Yes,
regarding
your
the
lordship.
non-examination.
Yes, your lordship. Now, your lordship, earlier while this insurance company came before this honorable court, that time their plea was that there is no medical report. Now, after that, while the matter was sent back, remanded back, then this claimant, he went to his native village where his treatment was taken, and from there he has obtained this certificate from the board, comprising 4 doctors. 4 doctors. And this is this exhibit P11, probably, your lordship. Exhibit P11. P11, your lordship. And regarding his injury, and your lordship, this is a beneficial legislation. Again and again, I'm approaching before this honorable court there.
No one is denying that.
Yes, your
the
lordship.
only thing is the calculation.
Calculation. Yes, your lordship. Here
if it
is
is wrongly calculated, then we have no choice.
yes, your lordship.
Remand it
Here, your lordship. 45% disability has been given. 45% disability.
45% is the disability.
Yes,
But
your
what is
lordship.
the loss of earning capacity? Has that been calculated?
45%.
No, it cannot be.
Loss of no.
It
not,
cannot be the same as the percentage of disability.
your
Never,
lordship.
never.
Your lordship. This
Where
tribunal.
is P11?
Tribunal is P11. P10 is the
Issued by a board.
P11 is the
Here we have only till exhibit P10.
P10 exhibit P10 medical
P10.
report P10.
Exhibit P10.
This will be huge bunch and
Oh, acha. All this diagnostic
yes,
lab,
yes, and then
it is in this. Can you just find it?
because additional witness was given. Oh no, exhibit P11. I'm correct. Exhibit P11. Because earlier medical documents were exhibited as P10. So when this honorable court has remanded back, then this claimant he has gone to his village from where his treatment was taken, and from there he has brought this medical certificate issued by the board. There are 4 doctors, Your Lordship, and they have ascertained his disability as 45%. Now, Your Lordship, I beg to take Your Lordship to their evidence, insurance company evidence, DW2. It is in page 24. Page 24, DW2. Insurance company.
Yes.
B2 NHR.
DW2.
Yes, Your Lordship. His insurer, this is earlier no evidence was taken from the insurance company. After remanding it back, insurance company has come forward and they have reduced their evidence.
Okay.
Now, Your Lordship, because I have to read that one, Your Lordship. Otherwise, I have been deputed by the insurance company, that is Oriental Insurance Company Limited, Divisional Office, Dimapur, Nagaland, to investigate in the said claim. As such, I am fully conversant with the facts to appear before this learned tribunal to depose my statement as defense witness number 2 on behalf of the opposite party number 3, Oriental Insurance Company Limited. That I am the investigator in the instant case, and during my investigations, I have visited the officer in charge of the police station Khatkati, District Karbi Anglong, Assam, and found that the accident occurred on 6/1/2013 at around 8:10 p.m. at NH29 near toll tax gate, Lahore region, out of which one pedestrian, namely Ajay Kumar Singh, got injured. I have also visited the Ma Bhavani Diagnostic Lab, Hospital Chowk, Motihari. Insurance company has gone up to Motihari, Your Lordship. Motihari, where the claimant took medical treatment for his injuries from such and such, and found that the claimant has undergone treatment in the said hospital. I have also visited the proprietor of Sudha Automobiles and Engineering Works, and I am confirmed that the claimant was employed under him as mechanic and was earning a salary of such and such, such and such. Now, Your Lordship, that the Lordship in this MSCT cases, Your Lordship, because since it is a beneficial legislation, so only the vehicle owner and driver, they are allowed to contest the case. But if they do not participate in the case, then insurance company has to ask for special permission under section 170 of MB Act. However, the insurance company was given the right to contest the case. Because Your Lordship will appreciate that this is a beneficial legislation, and a person who was injured way back in 2013, and it is now 2026, and one after another, again and again.
No, we are not denying any of those statements. You are entitled to compensation. That's a fact.
Now, Your Lordship.
But calculation part, how without examining the doctor and without coming to a conclusion regarding the loss of earning capacity, how the tribunal has calculated? Because the percentage
85%
is very
is
clear.
45%.
That is the percentage of disability.
Yes, Your Lordship. And
That is
now,
not the loss of earning capacity.
now, Your Lordship, if Your Lordship come to this judgment and order dated, impugn order dated,
Page 27.
page number 7, impugn order
Page 27.
27.
The next year's.
Yes. Statement. Yes, Your Lordship. Now, Your Lordship, that issue number, page 31, Your Lordship. Page 31. Upon hearing the learned counsel for the parties and on perusal of the records, this tribunal is of the view that since the scheme granting compensation in MSC cases are beneficial legislation, hence the same is to be dealt with avoiding strict scrutiny. The police report issued by IO OC Khotpoti PS such and such is seen categorical that on 6 such and such, the claimant was knocked down by a motorcycle such and such near Laurijan Tolna Karbi Anglong. Resultantly, the claimant received injuries causing permanent disability 40%, but there is no rebuttal adducing the evidence to negate the averments of the claimant regarding the accident took place on such and such, including the motorcycle. Over and above, the document of the opposite party number 3 corroborates the factum of the and is also categorical that the claimant on receipt of grievous injuries shifted to Bihar for availing specialized medical treatment. The DW1 and DW2 have also in their evidence confirmed the factum of the upon consideration of the submission made by the learned counsel for the parties. This tribunals is convinced that the case of the claimant as regards to the accident is well proved. Thus, the issue decided in favor of the. This is pertaining to the accident, Your Lordship. Why I have referred here, Your Lordship? Because in ground they have also stated the accident has not been proved. And Your Lordship, in this regard, res ipsa loquitur, there is a
They are not pressing. They are not pressing.
Now, Your Lordship, now in their they are issuing only one, that disability certificate. Now, disability certificate, earlier disability certificate was not there, Your Lordship. Now, disability certificate has been placed before the tribunal, issued by the 4 doctors, Your Lordship, not a single doctor. And my learned friend, while referring this Gauhati High Court, this court authority, there the doctor was single doctor. But here there is 4 doctors, Your Lordship. This may be appreciated. Now, regarding this, now, Your Lordship, if the insurance company was given opportunity to participate in the case, if the insurance company was having an evidence, they should have brought their doctor and examined whether such a disability was caused to the claimant or not, because it is a beneficial legislation. Now, calculation part, Your Lordship.
No, calculation also I have seen.
Monthly income 9,000.
See,
12 into
45% that disability percentage has been taken as the loss of income, as a loss of earning capacity.
Yes. Now, 45% disability, Your Lordship. If one person dies, then 100% calculation is given. Now he is having 45%. So that is 45%. 12 into 9,000 into 14 is that calculation multiplier into 45%, Your Lordship. The tribunal has taken 45%, not 100%, Your Lordship. Only 45%.
See, this Raj Kumar, Ajay Kumar case,
My lord.
some tribunals wrongly assume that in all cases, a particular percentage of permanent disability would result in a corresponding loss of earning capacity. And consequently, if the evidence produced shows 45% as permanent disability, will hold that there is 45% loss of future earning capacity.
Yes,
So
Your
that is what the High Court has, the Supreme
Yes,
Court
Your-
has said
yes, Your
that
Lordship,
it should
and
not
here-
be done.
Here this 45% has been
Because
taken.
the tribunal should not mechanically apply the percentage of permanent disability as the percentage of loss of earning capacity.
Now,
It's
Your
very clear.
Lordship, now, Your Lordship.
Because here, in
Yes,
the
Your Lordship.
findings of the tribunal, I've nowhere seen any calculation saying because of this, he was a mechanic, he was this, so that's why this much he has suffered, and his hands or his legs, whatever, so accordingly, this much percentage of loss of future earning capacity, nothing is there.
But here it
Only
is
that 40% disability, so 40%. So
45%. Your Lordship.
45%.
45%.
That
Now,
has-
Your Lordship,
that
the
has
matter
not
is
been
being
calculated.
dragged since 2013, Your Lordship. Now almost,
No, we will give a direction for expeditious disposal.
now, Your Lordship, it is second time it is going, Your Lordship.
What
Now,
can we do?
this
What
honorable
can-
court is also
what can we
having,
do?
this honorable court basing upon this 45%, if this honorable court calculate,
No, but doctor has not been examined also. Doctor has not been examined.
but here, Your Lordship, examination of doctor, because this honorable court and other, that is should not be strictly applied, Your Lordship, because if they are having any objection to that, they could have brought their doctor, Your Lordship. Now it will be a denial of this compensation to the claimant, Your Lordship,
No, it
who
is
is
not, it is not denial,
who is suffering since 2014, Your Lordship.
just some delay.
Lordship, in
Okay,
the
yes.
Honorable Court order, High Court order, it is clearly stated that to examine the doctor.
That's what,
And they have
that's
not
why.
complied by it, Lordship.
No, Your Lordship, this is not correct, Your Lordship.
Further, no medical doctor was examined.
No, yes, Your Lordship, loss have been come to the
Yes.
respondent. No, number one claimant as Lanet Tribunal could not have proved that the 40%. Where is the doctor? And the permanent disability certificate was not given earlier, Your Lordship.
When it is produced also, it has to be proved.
Lordship.
Now, Your
It has to
Lordship,
be
this,
proved.
since it is a
It has to
beneficial
be
legislation, Your Lordship, since it is a beneficial legislation, Your Lordship, then regarding this author of the documents, author of the
One of the doctors could have been examined, one of them.
author of the documents has not been does not require to be what it is called examined in beneficial legislation, Your Lordship. This Rajwati, Your Lordship, this Rajwati case, Your Lordship, and
See,
this honorable court.
See, para 818 of the same judgment, it says there are instances of unscrupulous doctors who, without treating the injured, readily give liberal disability certificates. But where the disability certificates are given by duly constituted medical boards, they may be accepted subject to evidence. Subject
Now, Your
to
Lordship-
evidence regarding the genuineness of such certificates.
Yes, Your Lordship, they have given it is been before the tribunal, Your
So
Lordship.
so that was produced by the claimant. No one was examined
Now-
to prove the genuineness.
Now, Your
Yes,
Lordship,
heard learned counsel for the petitioner, Mr. L. Pom, no? L.
Yes.
Pom for the appellant, sorry, not petitioner. Also heard Mr.
now,
Pom
Your
for-
Lordship,
yes.
I beg to Your Lordship to this order, Your Lordship, this honorable court, that non-examination of author. 9.
No, but what I'm saying is, can
Yes, Your Lordship.
this court go beyond this Supreme Court judgment?
Now, Your Lordship, the Supreme Court has, this honorable court has referred Supreme Court judgment, page 9, para 9,
Which one? Which one?
page 9, para 9. Rajwati. Learned Counsel also placed reliance on such and such. In the,
Yes, accepted.
yes, the Honorable Supreme Court further rejecting the salaried servant of the deceased merely on the ground that the person issuing the certificate was not examined before the tribunal is not correct view to be taken.
That is fine.
Now,
that is fine.
certificate issued by the-
Regarding salary certificate, that is fine. But for disability to calculate, because this is the main basis of the calculation. On this only calculation has to be done. Okay, so for this, all this is different, whether FIR is lodged, whether accident proof, that is okay, that is different.
Now,
Strict
so-
evidence may not be required.
My lord,
But
my lord,
here,
here certificate is given
how
by.
will the tribunal calculate when the disability certificate is not proved?
Now, your lordship, it is being given, and it is on the part of the insurance company to negate the same, your lordship. They have not negated the same.
And this court clearly said that doctor was not examined.
Lordship.
No,
So
your
tribunal
lordship.
should have taken note of that.
No, your lordship.
Okay,
it is-
anyway, yes, learned counsel, PP Paul also for the respondent claimant. Stop. This matter is disposed. I don't have time today since we are going at 2 to the new High Court side. So I will dispose in the chamber, okay? Chamber
My lord,
dispose. Chamber
my lord
dispose.
should think
We'll
on
see,
that
we'll
line
see.
that,
Lordship,
We'll see.
lordship,
Yes.
that it is a beneficial legislation, your lordship.
No, that is always in the mind. That is.
Lordship, direction may be given to withdraw the 25% statutory fee to withdraw.
We'll see. Here, some, just. Please, next.
If I may, Lordship, apology, we have deposited 50% of the one of.
Already deposited?
Yes.
Okay, 1 minute, huh?
It is twice deposited, your lordship, and we have not withdrawn.
Obliged.
Item number 6.
Please, your lordship. This is a matter regarding default bail, your lordship. The accused was arrested on 12/6/25, your lordship, and he was first produced before the magistrate on 13/6/2025. So counting from 13/6/2025, lordship, I've
No,
made a
no, wait,
complete
wait. Arrested on
12/6/2025.
12/6/2025.
First order of remand was passed on 13/6/2025.
13/6/2025.
So I made a table like this for easy reference. Lordship. You can also reference. So if it is counted from 13/6/2025, for the month of June, it was 18 days. July, 31 days. August, 31 days. September, 30 days. October, 31 days. November, 30 days. December from 1st to 9th. It's 9 days. So put all this together, the statutory period of 180 days, as per Section 36A, Clause 4 of the NDPS Act, ends on the 9th of December.
On 9 December.
Yes, your lordship. But however, since the accused was also put under preventive detention, the accused did not apply for default bail at that point of time, and that
Preventive detention under PIT and TPS.
yes, your lordship. However, that order also was set aside and quashed by this honorable court on 30/1/2026. So thereafter, before coming to this court, we approached the special court on with a bail for releasing the accused on default. That was disposed of on 11/2/2026.
11 to
I've mentioned this in para 6 of my.
Let's see the order of the Sessions Court, Special Judge.
Yes, it's at page 65.
You had prayed on the ground of default bail.
Yes, your lordship. Page 65, annexure 11. Operative part is from para 7. Yes.
Before the special judge lordship, they have on the ground of arrest was not served to the accused,
Oh, grounds of arrest.
ground of arrest.
That was also one of the grounds. But then the order speaks itself. It's only a 2-page order. Bail. May I read your
Yes,
lordship?
yes, yes.
From the first para or just the last relevant?
Just see, let's see the findings and then the
Yes,
operative
lordship.
portion.
Yeah. Then let me read from the objection of the APP. It's at para 5, your lordship, bottom of page 65. Prosecution has strongly objected to the move for default bail, as the detention period served under PIT and DPS cannot be counted to compute the mandatory period of 180 days. It is argued that executive detention cannot be connected with judicial remand, as the detention is preventive in nature and such detention is neither punitive nor pursuant to an order of remand passed by a criminal court, and therefore does not amount to judicial custody contemplated under Section 187 BNSS, read with Section 36A, Clause 4 of the NDPS Act. Heard the arguments of both sides, perused the applications and the documents wherein the accused was placed under preventive detention and subsequently revoked. The Honorable Supreme Court has consistently held that preventive detention and criminal prosecution operate in distinct and separate fields, and that detention under a preventive detention law cannot be equated with custody pursuant to a judicial remand. The right to default bail under Section 187, Clause 2, BNSS, read with Section 36A, Clause 4 of the NDPS Act, accrues only upon expiry of the prescribed statutory period, while the accused is in judicial custody, pursuant to an order of remand passed by a competent court. The period during which the accused remained under preventive detention under the PIT NDPS cannot be taken into account for computation of the statutory period for filing of the charge sheet in a criminal prosecution. While computing the time, the statutory period of the as prescribed have not been expired. Consequently, no indivisible right to default bail has accrued in favor of the accused. Bail is rejected and the application. So, in a way, the trial court is both agreeing and disagreeing. It's like in civil matters we call appropriate and inappropriate. They are both agreeing that they run differently. At the same time, when it comes to the computation of the remand period, they are saying it will not be counted. This interpretation cannot be gone into. Why? Because it's a legislative command, and it's very clear in CRPC and BNSS. The special court does not have power to read into the legislative act. That's my main submission, Your Lordship. And when it comes to default bail, it's just that the accused had to,
So on the ground that you were under detention, under the preventive detention law, it
that
was
period
rejected,
will not.
and that period will not be counted.
Yes, they're contradicting themselves, and not even a
How can that be? Because during when he is in detention in the jail, in regard to the PIT and DPS, what stops the investigating agency from going there and investigating? They can always take his statements, do everything. There's nothing to stop them.
Lordship.
So that period will run.
Lordship.
So automatically the 180 days has expired on 9/12.
Lordship.
Heard learned counsel for the petitioner, Mr. Pokim Yadan. Stop also heard Mr. V. Jimomi, learned public prosecutor for the state respondent. Stop.
Lordship, on the last occasion to produce the CT, Lordship.
But since the question is mainly this regarding the default only, no? The instant application under section 483 of the BNSS, read with section 187 BNSS and section 37 of the NDPS Act, has been filed, praying for release of the accused Mr. What's the name of the accused? Mr. Durg Singh, D-U-R-G, Durg Singh, on bail in connection with who has been arrested on 12/6/2025 in connection with special case number 14/2025 arising out of narcotics cell PS case number 6/2025 under section 21C/27A NDPS Act, read with section 61 of the BNS. Stop. Para. The case of the applicant herein, who is the brother-in-law of the accused person, is it?
Yes.
who is the brother-in-law of the accused person and duly authorized, is that the accused person was arrested on 12/6/2025 in connection with the aforementioned case. Thereafter, the accused was remanded to. Thereafter, the first date of remand was on 13/6/2025. Stop. It is also stated that since the date of first remand, i.e. 13/6/2025, the period of 180 days, 180 days as mandated in section 36A, big A, okay, 36A, clause 1, clause 5, is it? No.
Clause
36A, clause 4, as mandated in section 36, clause A, clause 4 of the NDPS Act, has since expired on 9/12/2025, and therefore the accused person has acquired an indefeasible right to be released on bail. Stop. It is stated that a bail application on this ground was moved before the Special Judge NDPS Kohima, and by order dated 11/2/2026, the same was rejected on the ground that the detention period served under PIT NDPS Act cannot be counted to compute the mandatory period of 180 days. No, before that, you say the learned counsel submits that the accused was also detained under the PIT NDPS Act from period
7 October 2025. Annex 9,
Annex 9, 7.
page 4.
page
Page 40.
40,
40 also.
7/10/2025.
from 7/10/2025
To 14/11/2025.
14/11.
The extension.
No. The revocation.
This was. It was extended, which was quashed and set aside by this honorable court on 31/2026.
31/2026, na?
Yes, Your Worship.
Up to 31/2026. Stop. Then after that you come to that before the special court, na? Then which was rejected by order dated 11/2/2026, on the ground that the period spent spent in pursuance of the preventive detention order cannot be stated to be what the court says, cannot be computed towards the 180 days in judicial custody pursuant to an order of remand by a competent court. Stop. The learned trial court stated that the period during which the accused remained under preventive detention under the PIT NDPS Act cannot be taken into account as the statutory period, cannot be taken into account towards the statutory period for filing of the charge sheet in the criminal prosecution. Stop. Accordingly, the court was of the view that no indefeasible right to default bail has accrued in favor of the accused. Stop. Para. In the present application, the applicant has taken the same ground of default bail and has stated that that there was nothing which stopped the investigating agency from continuing the investigation even when the accused was in custody in view of the detention under the PIT and TPS Act. Stop. The Learned Counsel has therefore prayed that the right to bail has since accrued to the accused person on 9/12/2025, and therefore it is prayed that the accused person may be released on default bail. Stop. Para.
And I'm willing to offer statute security. That I'm willing to.
And that he is willing to abide by any conditions which this court may impose. Stop. Para, Learned Public Prosecutor, Mr. V. Jimomi, appearing for the state respondents, has fairly submitted that the period of 180 days, that the statutory period of 180 days, as provided in section 36, clause A, clause 4 of the NDPS Act, has expired on 9/12/2025, as the investigation period has to be counted from the date of first remand, i.e. 13/6/2025. Stop. Para. Having considered the submissions of the Learned Counsel for the petitioner, and after going through the records, this court is of the view that the period of 180 days as mandated in section 36, clause A, clause 4 of the NDPS Act has expired on 9/12/2025 as contended by the Learned Counsel for the petitioner, inasmuch as the investigating agency was at liberty to continue with the investigation even when the accused person was in custody under preventive detention under the PIT and TPS Act. Stop. Accordingly, the application is allowed, and the accused person, Mr. Durg Singh, is allowed to go on default bail subject to the following conditions. Dash number 1, execution of a bail bond for rupees 30,000 with, can you provide local surety?
Yes, Your Lordship, that's what they said. I also wanted to know.
With one local surety of like amount. So number 2, to the satisfaction of the trial court, okay, to the satisfaction of the trial court. So number 2, the accused shall appear before the investigating agency as and when summoned without fail. Number 3, or we can say appear before the IO every 2 weeks.
Already.
Shall appear before the IO every 2 weeks till the investigation is completed. So, then number 3, the accused person shall not leave the jurisdiction of the trial court without the permission of the court thereof. And the accused shall also not hamper the investigation or shall not tamper with the evidence and shall not try to influence the witnesses in any manner. So, with the above directions, this petition stands disposed.
Item number 7.
Please, Your Lordship.
Yes.
Lordship, this is a subsequent bail application. Lordship, I continue, Lordship. Yes. Earlier, I've moved a bail application before the principal district and sessions. However, the matter, the bail got rejected by white order dated 11/2/2026. I have annexed this
Page
bail order at page 15, annexure 2.
15. Yes.
Lordship, however, before going into the to the order. May I show your lordship the FIR first?
Okay.
FIR is at page 19, annexure 3. It's a sumoto FIR. So, lordship, as per this FIR, there is an allegation that several people have been duped by one company by the name and style RGA company. Now, in this FIR, no name has been reflected. Even the petitioner's name was not reflected, nor there is any hint shown in the FIR that the petitioner is involved in this so-called RGA scam. For the sake of brevity, I shall not go into the. I shall not be reading the entire FIR.
Not
Lordship.
named in the FIR. Yes, then?
Lordship, and then the name of the petitioner surfaced, subsequently surfaced only at the in one correspondence. This your lordship will find at annexure 4, page 23. This is an application prayer for non-bailable warrant of arrest to arrest the present petitioner. Lordship, may I read?
Yes, please read.
To the Chief Judicial Magistrate, Kohima, Nagaland, subject prayer for non-bailable warrant of arrest, state crime reference, state crime PS, case number 3 of 2024, under section 111346 and section 318, clause 2, 3, and 4. Ma'am, with reference to the subject cited above, I have the honor to state that the below noted accused person is involved in connection with the above referred case, wherein several individuals in Nagaland have been scammed of crores of amount in RGA scam, and it is found that the below noted accused is director of the company named EDI Packages Delivery Services Private Limited, which paid the salary of those involved in the and engaged in the RGA scam. The suspect further appears to be a master kingpin in the entire cyber fraud network of the RGA scam, wherein UPI transaction records and money trial analysis strongly indicates that the suspect was planning, supervising, and directing the activities of the cooperative in the scam. That the below noted accused, namely Ejaz Salim Sheikh, is absconding despite the attempt of the investigating officer to serve him notice under 35.3 BNSS. Further, the IO has made several attempts through the local police in Pune to serve notice to the known residence and workplace of the accused, contacted relatives and conducted local inquiries, but the accused has absconded from his ordinary residence and his present whereabouts are unknown. That the conduct of the suspect clearly reflects his intention to obstruct investigation, and his continued evasion is hampering the progress of the investigation. It is therefore most respectfully prayed that this honorable court may kindly be pleased to issue a non-bailable warrant of arrest against the accused, namely Ejaz Salim Sheikh, in the interest of police investigation. Lordship, I will come to this later if your Lordship requires any clarification. However, the present petitioner, Lordship, going back to the inception of how he was arrested, he was initially arrested by Jamnagar, Gujarat, district in Gujarat, police in connection to a cybercrime case. Which is
case.
in a different case, distinctly different and separate, which has no connection with the RGA scam. Now, while he was in judicial, in jail, at district jail of Jamnagar, he was shown arrested on 17th January 2026. Now, on being shown arrested, he was produced before the magistrates, second-class magistrate, and then 7 days judicial remand was issued transit remand was issued, and he was brought to Kohima on 20th. And Lordship, this, I raised the very issue that there is a procedural violation insofar as grounds of arrest, communication of grounds of arrest is concerned, that there is a violation of Article 22 as well as the settled position of law before the trial court also. And Lordship, before the trial court, Lordship may kindly see the relevant page at page 32. A type copy is in page 33. However,
This is the grounds of arrest.
the grounds of arrest. Lordship, at the bottom, besides the grounds of arrest being intimated to the accused person, it is the settled position of law that it has to be furnished in written to the family or to a nominated person, Lordship knows. Now, this is purportedly furnished to Mr. Rashid, advocate, and Anzalna Sheikh, the wife of the petitioner. However, Lordship, this has never been furnished, grounds of arrest has never been furnished. I've submitted this before the trial court also, and Lordship, in this regard, this very bench, this honorable court, this very bench has.
No, but
Has-
here
has
your
ruled.
your signature is there.
No, Lordship, this is not my signature.
Signature, thumb impression of arrested person. At the bottom,
Lordship,
page 32.
Perhaps this is the signature of the. Accused signature is there, Lordship. That I admit.
accused
However, the signature of the family members, or for that matter, the advocate, whose name is reflected here as the nominated person of the accused, the name is not reflected here. Lordship, may I take your Lordship to para 7 of this ruling? May I read, Lordship? This court has given due consideration to the submission of the learned counsels and have perused the case diary which is produced by the learned PP. Upon going through the case diary, it is seen that as far as the accused is concerned, the arrest memo, rights of arrested person, grounds of arrest, right to bail, and all other requirements have been communicated to the accused person in writing and also read out and explained to him in the language he understands. However, as far as the wife of the accused is concerned, there is only a remark that intimation of the arrest was given to the wife under Section 48 BNSS. There is nothing to show from the records that the grounds of arrest was intimated in writing to the wife, also which is a mandate of Article 22 of the Constitution. It is the requirement of law that the grounds of arrest have to be intimated to relative, friends, or such other persons as disclosed or nominated by the arrested person for the purpose of giving such information. According to Section 48 BNSS, it is a requirement of law that such grounds of arrest in writing have to be acknowledged and signed by the wife, relative, or the same has to be on record. This court is unable to find any such record on receipt of the grounds of arrest from the wife, relative of the arrested person. In view of the above observations, the discussion, this court is of the view that the requirement of Section 48 BNSS and the mandate of Article 22(1) of the Constitution has been violated in the present case. Accordingly, the petition is allowed. Now, Lordship, there is no signature, no acknowledgement receipt on the grounds of arrest. As far as the wife and Mr. Rashid is concerned. And Lordship,
There is one signature, of course, in the bottom.
Lordship, this is the signature of the Peshkar who has issued this, the CTC, Lordship. Except for that, and I have raised this very ground before the learned court below. However, during the time of hearing, the prosecution has apprised this honorable court that through WhatsApp transmission, the grounds of arrest has been transmitted to the wife as well as to the mother of the petitioner. However, this has been verified. Grounds of arrest has never been sent to the wife, nor for that matter to the advocate. And it was later found that grounds of arrest was, in fact, it was communicated to the mother of the accused person. However, at a very belated stage, after several days, Lordship, only on 22nd, he was arrested on 17th. However, only on 22nd, this WhatsApp transmission was relayed to the accused mother. Now the accused mother does not understand or could not comprehend what the ground of this document entails. And therefore, initially I was not given that proper instruction also, since she does not know that it is the grounds of arrest. So on this count also, firstly, that there is no signature, no acknowledgement. Secondly, on the ground that the grounds of arrest was furnished to the mother in a language she cannot understand. And Lordship, can please? This is the WhatsApp communication. It's barely legible, so I have a typed copy in the next page. So the date shows that it's 22nd January 2026. Therefore, Lordship, and I am before this honorable court on those two grounds, as well as that even assuming that grounds of arrest is being communicated to the family members or the concerned person nominated by the petitioner. If it is communicated at a very belated stage, then that also violates the safeguards of safeguards of the mandatory requirement of grounds of arrest. Lordship.
Okay. These are the, we will have to see the records for this. We have to ascertain the signatures.
Lordship.
And then any other ground?
Lordship have the BNSS with you. So, and Lordship knows that Section 48, 48, permit me to read this.
Yes.
Obligation of person making arrest to inform about arrest, etc., to relative or friend. 1. Every police officer or other persons making any arrest under the Sanhita shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his relatives, friends, or such other persons as may be disclosed or nominated by the arrested person for the purpose of giving such information, and also to designate police officer in the district. Lordship, the language employed here is forthwith. And Lordship knows that as per the ratio of Vihan Kumar,
No, it's all there. Vihan Kumar, Prukayasta, it's all there. But then
Yes,
it has to,
Lordship.
we have to see the facts and circumstances of each case.
Lordship, I respectfully agree, Lordship. My contention is that, Lordship, as per Vihan Kumar, relative have to be intimated, and the language employed here also, Lordship. That is important, so I may be permitted to read this. Just
Para?
para 42. I'm relying on para 41 and 42, but for now I'll just dwell on 42. For the purpose of showing this court that wrong actions have to be taken. 42, the purpose of inserting section 50A CRPC, making it obligatory on the persons making arrest to inform about the arrest to the friends, relatives, and persons nominated by the arrested person is to ensure that they would be able to take immediate and prompt actions to secure the release of the arrested person as permissible under law. The arrested person, because of his detention, may not have immediate and easy access to legal process for securing his release, which would otherwise be available to friends, relatives, and such nominated persons by way of engaging lawyers, briefing them to secure release of the detained person on bail at the earliest. Therefore, the purpose of communicating the grounds of arrest to the detainee, in addition to his relatives, and as mentioned above, is not merely a formality, but to enable the detained person to know the reasons for his arrest, but also to provide the necessary opportunity to him through his relatives, friends, and nominated persons to secure his release at the earliest possible opportunity for actualizing the fundamental rights to liberty and liberty and life as guaranteed under Article 21 of the Constitution. Hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or as such persons as may be disclosed to nominate or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which the arrest may be rendered illegal. So prompt and immediate actions have to be taken while furnishing grounds of arrest, Lordship. Lordship, and while mentioning prompt, or for that matter, a reasonable time for communication of these grounds of arrest, I'm relying on another Supreme Court ruling, Mahir Rajesh Shah versus State of Maharashtra. I'll take your Lordship to para 30, 62, and 65.
30.
30, Lordship.
Yes. It is further observed.
It was further observed that to ensure the effective implementation of the constitutional mandate in Article 22, the law further requests such grounds to be effectively communicated not only to the detainee arrest, but also to their friends, relatives, or any other nominated persons, as envisaged in Section 50A CRPC. The legislative intent behind the incorporation of 50A CRPC is to ensure that those in the position to act, secure legal representation, initiate the process for bail, are empowered to do so without any delay, thereby safeguarding the fundamental rights of the arrested person as enshrined in Article 21 of the Constitution of India. Also, what you can kindly see.
When was this WhatsApp sent to the mother?
On 22nd,
22nd.
after a delay of five days. So the question of the definition of reasonable is discussed here, Lordship, at 58, Lordship. Para 58. That's your Lordship, 42. It is by now settled that if the grounds of arrest are not furnished to the arrestee in writing, this non-compliance will result in breach of the constitutional and statutory safeguard, hence rendering the arrest and remand illegal, and the person will be entitled to be set at liberty. The statute is silent with regard to the mode, nature, or the time and stage at which the grounds of arrest has to be communicated. Article 22 says that as soon as may be, which would obviously not mean prior to arrest, but can be on arrest or thereafter. The indication is as early as it can be conveyed. There may be a situation wherein it may not be practically possible to supply such grounds of arrest to the arrested person at the time of the arrest or immediately. Now at the bottom, para 62, we thus hold that in cases where the police are already in possession of the documents, material furnished, furnishing a cogent basis for the arrest, the written grounds of arrest must be furnished to the arrestee on his arrest. However, in exceptional circumstances, such an offense as against body or property committed in flagrante delicto, where informing the grounds of arrest in writing on arrest rendered impractical. It shall be sufficient for the police officer or other persons making the arrest to orally convey the same person to the person at the time of arrest. Later, a written copy of grounds of arrest must be supplied to the arrested person within a reasonable time and in no event later than 2 hours prior to production of the arrestee before the magistrate for remand proceedings. The remand papers shall contain the grounds of arrest, and in the case there is a delay in supply thereof, a note indicating a cause for it to be included in the information of the magistrate. The above indicated lower limit of 2 hours minimum interval before the production is grounded in the functional necessity, so that the rights of the rights as provided to an arrestee under the Constitution and the statute is safeguarded effectively. This period would ensure that the council has adequate time to scrutinize the basis of arrest and gather relevant materials to defend the arrestee proficiently and capably while opposing the remand. Any shorter interval may render such preparation illusory, thereby resulting in non-compliance of the constitutional and statutory mandate. The 2-hour threshold before the production for remand, and thus strikes a judicial balance between safeguarding the arrestee's constitutional right under Article 22 and preserving the operational continuity of the criminal investigation.
Okay, let's see. Yes, anything else?
So initially when he was arrested, he was produced on 17 itself before the magistrate.
So as far as the intimation to accuse is concerned, that is already there. His signature is there.
Lordship, I'm not disputing that.
But you're only disputing regarding the relative.
Lordship.
Notice to relative. So let's see.
Lordship, I have some other grounds also.
What other grounds?
Medical ground, Lordship.
Medical ground.
Yes. Lordship.
For that medical ground, was it taken, that ground, was it taken earlier?
Lordship, I have taken this ground. However, at that point of time, documents were not available. So I was not able to produce any document before the learned principal district in sessions. Lordship, the petitioner is a high-risk diabetic patient, and he has been on regular insulin regimen for past several months. And despite regular medication, his HbA1c levels remain alarmingly high at 9.7, requiring medical monitoring, dietary and medication. Therefore, on this ground also, Lordship, I'm seeking enlargement
And
of
he
the
has
Lordship may
been in
kindly
custody
see
since 17/1/2026, 21/2026, February, March. Okay. So now, till as on date, how many days you have been in custody?
Lordship, I was in police custody for about 10 days, and thereafter, now I'm in custody for more than 30 days. In judicial custody for more than 30 days now.
No, counting the entire period, police remand also, 40.
More than 40, Lordship. I'll show you, Lordship, in a minute.
And the offenses
Offences,
charged
Lordship,
with,
yes.
the punishment would be
Section
section
111,
111.
clause 3, 4, and 6. Lordship,
Not less
111
than
pertains
5
to-
years, which may extend to imprisonment for life. Not less than 5 years, which may extend to imprisonment for life.
Lordship, I admit that the charges
Serious
are
charges.
serious.
Serious
The
charges.
charges are serious in nature. However, there is no prima facie case in the present case that he has not been named anywhere, nor his bank accounts. Lordship has never does not have any record that is linked to this RGS scam also, Lordship. And Lordship may kindly
Okay, then.
see the medical report at page 34. At annexure 7.
Condition of the patient. Discharge.
Right after.
These are before arrest, the medical
Yes,
reports.
Lordship, I want to show your Lordship this record, since this is of 16 August 2025, and in the chart, Lordship, at number 3, box number 3. Now, Lordship will find that insulin, since this time, since August 2025, he was on insulin. And in the next page, at page 35, in the first, or in the second box, second chart, Lordship will find that a figure where it indicates 9.0%.
9.0%.
This is the HbA1c level.
So what is the normal level? What should
Lordship, I'll show you, Lordship.
HbA1c?
Lordship, may kindly see page 40. As per the medical doctor's statement.
Page 40.
Page 40, Lordship. HbA1c is the sugar monitoring record for 3 months.
Okay,
So
4
at
to
chart number
6.4.
1, yes. Normal should be 4 to 6.4. However, it has increased after he has brought here. Lordship, this medical examination is dated 19/2/2026.
Okay. Yes.
Lordship, before I
Yeah.
conclude,
I
he has
have
been,
to
yes,
rise by
55
one, that's why.
55 days he has been in custody.
50?
55 days.
55 days.
That's all for my
What is
submission, unless
the
your
stage of
lordship
the
wants.
investigation?
My lord, charges have not been submitted now.
Not been submitted.
Yes. My lord, since it is a bail petition, my lord, I'm not going into the facts, my lord, and that facts will be proved during the trial. In regard to first ground, my lord, in that
grounds
non-furnishing
of
of,
arrest.
yes, my lord. The lordship may kindly see the CD. May I read, my lord? Now, upon reaching Jamakar, Gujarat, self along with team reported to the Court of IC, Second Additional Chief Judicial Magistrate Jamnagar Court, and produced the shown arrest order from Chief Judicial Magistrate Kohima, along with all necessary documents in connection with the case, along with prayer for transit remand. In this connection, IC Second Additional Chief Judicial Magistrate Jamnagar Court directed to take safe custody of the accused from Jamnagar jail, and also such took safe custody of the accused from the jailer along with court order. Further, upon protections of accused to second class CJM, Jamnagar, the court granted 7 days transit remand for further protection before the CJM Kohima. After sworn arrest of accused, a copy of arrest, rights of arrest, grounds of arrest was handed over to the accused advocate at Jamnagar court and further forwarded to the accused mother through WhatsApp, since he was from Pune and no relatives or representative was present at Jamnagar. Further, the accused was medically examined and kept for safety custody at city police station for the night. My lord, here on the same day, that is on 17/1/2026, all the necessary documents was furnished to the accused advocate. And since the relatives were not present on Jamnagar, through WhatsApp, those necessary documents were sent to her mother, my lord,
But
to his mother.
it appears that that was received only on 22nd January, the WhatsApp.
And your lordship may kindly see the format, page number 32 of the petition, my lord. Here, the format was prepared on 17/1/2026, on the same day, my lord. And here it clearly says that that communication was made to the accused and the family members. And below it clearly says that to his wife. So, my lord, under that mandate under Article 22, Clause 1 and Section 47 and 48 of PNSS is complied, my lord.
No, in the case diary entry, this is 17/1.
Yes, my
So
lord.
on 17/1, it is entered that the WhatsApp message was sent to the advocate and the mother.
Yes.
But then this printout shows that this was sent on 22/1. No, 20.
22, Lordship.
Which documents, my lord? I have not received any documents.
No. Just give him a copy. The WhatsApp message. (22:1). Just see on top.
But this is voice call only, my lord.
No, below that, two documents. Below that, there are two documents, rights and grounds.
Lordship, I must mention that this very document was also produced before the learned principal district and sessions.
Below this, because this is all on the same day,
Yes, ma'am.
on the same day. So it was sent, this is 17, so 5 days, 18, 19, 20, 21, 22, 5 days, after 5 days only.
Yes, ma'am.
So can that be said to be prompt?
As per the law, it should be forthwith, my lord.
It should be
Forthwith.
forthwith,
same, yes,
yes,
ma'am.
forthwith.
So in regard to my first ground submission, my lord, this section has been complied. And the secondly, in regard to the health issue, my lord, my humble submission is, for the interest of justice, your lordship may direct to constitute medical board to examine the health of the accused, my lord. Thereafter, passing on the report, your lordship may pass any necessary order, my lord.
And that format, grounds of arrest format is not here in your CD.
They have not enclosed, my lord.
Because what the petitioner has annexed is a photocopy.
Yes, ma'am.
So the court would like to see the original of this.
Then your lordship may kindly.
It should be, normally it is there in the,
Yes.
along with the case diary.
Then original documents may be, the
Tomorrow?
record may be
Tomorrow?
produced tomorrow, my lord. Yes.
Because that is the main thing on which the court has to pass
Yes,
its
madam.
order. Okay, just say pass over for the day. Pass over for the day, and the learned PP shall produce the original copy of the grounds of arrest. Okay.
Much obliged.
Obliged, Lordship.
Item number 4, item number 8.
Zima,
Zima, my lord.
yes. You are the owner.
Yes, my lord.
Where is the registration certificate?
Your Honor, the registration certificate is in Annexure D, page 19.
Very.
Before we proceed, my lord, may I go to the brief facts of the case, my lord? My lord,
No,
this is,
if you are the owner and you have no connection with the offense, the court will grant the zima. That's no problem.
My
But
lord,
you have to first ascertain your ownership.
yes, my lord. My lord, the original
Owner
RC
name is Jayanta Kalita.
yes, it's not in my name. But,
Then
but I have purchased from a registered sale dealer from the original owner, and I've executed a sale deed. After that,
where is
after
that?
sale deed is in Annexure C, page 18, my lord.
Page 18.
Yes, my lord. From car dealer JJ Highway Motors, my lord.
Have you given your statement to the IO?
Yes, my lord. I have given my statement and I've submitted the fact even before the special judge, my lord. It's in Para 3 of the order of the special judge, my lord.
What does it say in the IO's recording?
My lord, here, as per the city,
What does the IO say? Has
the
he
order is
recorded a
different.
statement? Huh? Owner is different.
honor is different, my lord. And they are saying that they have executed the sale deed. Your lordship may kindly see the city.
Acha, we'll give a direction to the IO to get the affidavit from this author of this sale deed. Who has issued this?
JJ Highway Motors, my lord.
So you you get a certificate from this person.
After, my lord, after I executed the sale deed, the owner, the original owner, he gave all the documents to me. After that, I applied for no objection certificate from the concerned department, Kachar district in Assam. So from the concerned department, I was issued the no objection certificate, my lord. And all the, still, since the vehicle is in the police custody, I could not apply for a registration certificate in my name, my lord.
My lord,
No, you have the contact number of this JJ Highway Motors. You must be having. So just give it to the IO and then let the IO get an affidavit from this person, from this JJ Motors, saying that it has been sold to you. Okay? That
my lord,
will do.
actually, the procedure should be, the registration name is different and the person who is claiming is different. He's saying that he purchased the vehicle from JJ
From
Highway
this
Motor.
JJ Highway
Then
Motors.
JJ Highway Motor is not the owner, my lord. So
They are the dealer, my lord.
yes, if
not
They are the
if
dealers.
they are the dealer, then there should be some documents that between the real owner and the JJ Motor, the agency. That document is
No, that's what I'm
also not there.
saying.
Yes, my lord.
Some affidavit
Yes.
by this JJ Highway Motors saying that the original owner had given it to him
Yes.
for sale. Okay, that will do. Heard learned counsel for the petitioner, Mr. Such and Such. Stop. Also heard Mr. Tibapum, the learned public prosecutor. Stop. The petitioner shall give his statement before the petitioner is directed. Petitioner is the owner. You are saying is the
Yes,
owner.
yes, my lord.
Is directed to approach the IO and give his statement regarding the claim of ownership, and thereafter the IO is directed to obtain a affidavit from JJ Highway Motors. You give the contact to the IO, okay? From JJ Highway Motors, affirming that the dealer has affirming that the original owner Jayanta is it the original owner Jayanta Kalita has given the said vehicle the concerned vehicle for sale to him, and that he has sold the same to the present petitioner. Okay, stop. The learned public prosecutor thereafter shall, no, the IO thereafter shall record the same in the case diary, and the learned PP shall produce the updated case diary on the next date. So, least after 2 weeks. You can do it in 2 weeks.
1 week, my lord.
No,
Least
2
2 weeks,
weeks,
2
at least
weeks.
after 2 weeks.
Yes, ma'am.
Much, my lord.
Much better.
So you go before the IO and you give the contact details of this JJ Motors, okay? And let the IO get an affidavit from them.
My lord.
Much better.
Orders, item number 9.
May I please, my lord?
Yes.
Lordship, in these contempt matters, I'm appearing for respondent number 1. I wanted to make a brief submission here, your lordship, as only with regard to respondent number 1, my lord. Lordship, see, this contempt is filed for non-compliance of this honorable court order dated 27/5/2025. Your lordship will find that at page 20 of the contempt petition.
Yes.
Now, your lordship, if you see here, the
consider.
No, your lordship, on the first page that is at page 20, I'm concerned here with page 20,
Page
my lord.
20.
Yes.
Page 20.
Yes. Your lordship, the state was represented by the commissioner and secretary, Home Department, the commissioner, PNAR department, the engineer in chief, and the chief engineer, your lordship. The contempt number 1 hearing, your lordship, is the chief secretary. And therefore, this direction, your lordship, that is 27/5/2025 was never directed, or no direction was issued.
He was not made a party.
Yes, he was never a party in the writ petition, and therefore no direction has been issued to him, your lordship.
May I please, Your Lordship?
Yes.
Lordship, this is the second round of litigation. So during the first round of litigation, by being WPC number 33 of 2020, respondent was a necessary party. So
In the first petition.
Lordship, yes.
So, but then in the first petition, what was the direction?
To revise the service of the petitioner within 3 months, Lordship. The relevant para starts from page 18 of the contempt petition. Para 26, page 18, para 26.
Okay, the direction was to regularize
Lordship.
within a period of 3 months.
Yes.
Lordship, they keep changing the offices, so if the respondent want to remain the same.
Yes, in the first petition,
Yes,
Chief
I
Secretary
agree.
was a party.
I agree,
No,
Your Lordship, but in,
no,
in
but
the,
the Chief
in-
Secretary is
Yes.
the executive head of the state.
Lordship.
So he will be responsible for any action.
No, Your Lordship, Your Lordship, I just wanted to read out some paras from the contempt petition itself, Your Lordship. Allow me to read para 1.
No, let it remain, and then you file an affidavit. If you wish to absolve him, you file an affidavit stating all this on behalf of R1.
Lordship, that also can be done, Your
Yes,
Lordship,
that
but
can
when
be
no
done.
direction has been issued to me.
No problem, because R1 is the Chief Secretary, so. he
No,
was
Your
a
Lordship,
part-
in WPC 61.
But in WP 33 is there.
Your Lordship, but they are aggrieved by non-compliance of WPC 61. Para 1, Your Lordship. Para 1 and the prayer. Para 1 of the writ petition, Your Lordship. Very clear.
In any case, it says that the case of the petitioner is being processed. Just see, as per Annexure 2, letter such and such, it is seen that the case of the petitioner is duly processed, as per the notification number such and such, dated 5/3/25.
Lordship,
So on that, basing on that submission, it was closed. Basing on the submission by
Yes.
the learned government advocate,
Yes.
that the case of the petitioner is being processed.
yes,
That's why it was closed.
yes. That in Your Lordship,
So
yes,
by now, see, this is an order of 27/5.
yes.
We are now in March 2026.
Yes.
So till now, the process is going on.
Lordship,
At that time also, 27/5, the
Yes.
government advocate said that the petitioner's case is being processed.
yes. Your Lordship, as far as the present contempt petition is concerned, we are concerned only with WPC 61 of 2025, not WPC, Your Lordship.
33.
Yes, not WPC 33, because the issue where the contempt has been filed is for non-compliance of WPC 61, not WPC 33, my lord. And also, Your Lordship.
Okay, okay.
And also, Your Lordship, at page 23, if you see the letter that has been submitted, I mean, the order that has been submitted by the petitioner,
Page?
page 23, Your Lordship. This will also
It was
show,
submitted to the other
yes,
respondents.
yes, not to the respondent number 1, Your Lordship.
Okay, okay. We'll delete that. Learned, yes.
I'm representing for respondent number 4. However, Lordship, now the respondent number 4, he has relinquished his office, Lordship. He has retired,
Retired.
Lordship. So the petitioner.
In any case, you have to file an IA to implement the new incumbents. Respondent 4 retired. Okay.
And respondent 2, 3. Now, as far as.
Respondent 3 also retired.
Lordship. Respondent 3,
R3 also retired. And 4 also.
Lordship. And respondent number 2, Home Commissioner.
Respondent 2 has also retired.
Yes.
Yes.
2, 3, and 4.
So 2, 3, and 4 all retired. Okay, learned counsel, Ms. Such and such is present for the petitioners. Stop at the outset, Mr. N. Angami, appearing for respondent number 1, submits that the direction in that the respondent number 1 was not a party in WPC 61 of 2025, and further the direction in the order dated 27/5/2025 in WP 61 of 2025 was directed against the respondents number 2, 3, and 4, and therefore he praised that the name of respondent number 1 may be struck off as a condemned respondent in the present case. Stop. This court has perused the order dated 27/5/2025 in WPC 61 of 2025, and it is seen that the respondent number 1 was not made a party in the said petition. Moreover, the notice of the court's order dated 27/5/2025 was also served only on the respondents number 2, 3, and 4, and not on the respondent number 1 by the petitioner. Stop. Accordingly, this court is of the view that the name of Mr. Respondent number 1 needs to be struck off from the list of the respondents. So it is directed that the name of respondent number 1 may be struck off from the array of respondents in this case. Stop. Para. Learned Counsel, Mr. V. Zimomi, appearing for the respondents number 2, respondent number 4, submits that the respondent number 4 has retired from service, and that respondent 2 and 3 have also retired, and it has been informed that respondent number 2 and 3 have also retired from service. Stop. In view of the said submission of the Learned Counsel, Mr. V. Zimomi, the Learned Counsel for the petitioner shall ascertain the names of the new incumbents and thereafter file an IA for implement if so advised. At least after 2 weeks. Yes. They can file. Let them file.
I'm deeply obliged, my lord.
Item number 10.
Lordship, the service upon the respondent number 2, 3, 4, and 5 have come in sufficient interest to Lordship. If 3 weeks' time may be given so that we can trace the address of the respondent.
To ascertain.
To ascertain, yes.
Learned Counsel for the appellant, Ms. Kim Penny is present. Stop. The office note dated 16/1/2026 indicates that the notice on respondent number 2, 3, 4, and 5 has returned back unserved with the remark, inverted commas, insufficient address, close inverted commas. Stop. The Learned Counsel prays that she may be given 3 weeks' time to ascertain the correct address and to take steps thereafter. Stop. Prayer is allowed list after 3 weeks.
Item number 11.
Today the matter is fixed for consideration of interim prayer.
I don't know whether we can take it up because we have a meeting at 2:30. Chief is here and we have to leave by 1:30. Anyway, and we have only 5 minutes left now.
I don't think, my lord.
Not possible, I think.
Can it be, my lord?
Notice not complete.
Not complete. My friend is appearing, madam.
My lady, I'll be appearing on behalf of the Special Public Prosecutor, Mr. A.K. Mishra, sir. My lady will be filing the wakalatnama for respondent number 1 to 6.
1 to 6.
Yes.
Okay.
And I also may be permitted to, as he is indisposed due to a leg fracture, so I may be permitted to place on record the medical certificate he has provided with. And
So when can he appear?
the doctor
Because
has,
one problem is that the goods are liable to be damaged if it's kept for a long time. So we need to dispose of at the earliest.
my lady, we are not in receipt of the writ petition also.
That you can get it today.
Yes, and as per the certificate, doctor has
Next
advised
week.
him.
Next
Doctor
week.
has advised him for 30 days because he has fractured his femur bone, the longest bone. So he has discharged. He has been discharged, I think, 2 to 3 days back only.
But in that case, my lord, what I am praying, my lord, they can keep a sample of that areca nuts for their examination, my lord. For that, my lord, entire goods are not required to be detained, my lord. If, my lord, they want to pursue, they can keep areca nut. And so far as there are allegation that e-way bill, as per the GST, although they are not authorized, in that case, my lord, 5% tax is there. Against, my lord, we will furnish a bank guarantee against, my lord, that applicable taxes of the bank. So they are concerned with the taxes, my lord. That will furnish. And so far as that foreign origin and all, finally you also will hear. Otherwise, my lord, they have no jurisdiction. I will satisfy, my lord.
No, the problem is if with this court finds that it is of foreign origin, And then if it is liable to be
Now this is their,
confiscated, then
this is not their allegation, my lord. Initially they alleged that it was foreign origin. Now they are saying different thing, my lord. That's why page 50, my lord, kindly see.
no, I remember something about this case saying that or foreign origin and
They
all
are
that.
saying, at the time of seizure, they are saying foreign, page 50.
Suspected to be a foreign
Suspect,
origin.
my lord. Subsequently, my lord, what they are saying, page 56, at the time of release, provisional release, they are saying that it is observed that, page 56, my lord, it is observed that at the time of interception, the vehicle was transported goods without generation of valid e-way bill. As per section so of CGST Act, so and so, there is not a single whisper about my lord, foreign origin now. And regarding GST, my lord, GST Act is complete code. For that one, GST authority will do. How custom can enter in
68 of the GST Act, which read 138 of the GST rules, generation of e-way bill.
They are saying there was no e-way bill. If there is a violation of some certain provision of GST, for that one GST Act is complete code, they will take care, my lord. Initially they are saying suspected to be foreign origin. At the time of, and that also, my lord, Apex Court says, in case of reason to believe, my lord, suspicion will not do. There has to be more than that, I will place, my lord. Only on the basis of suspicion, goods cannot be seized, my lord. Page 50.
No, vehicle is also there.
Vehicle is also there, my
Vehicle
lord.
bearing such and such.
It will be deteriorated, my lord, the condition of both from last 4 months, my lord.
In that case, we'll release conditionally.
My lady, as of today, I do not have such instructions. So if
No, you know that the order is there that the interim will be considered today.
no, I was just advised to file the wakalatnama just last night through a telephonic call, and I have not really
Or
received
in the alternative, it can be heard next week.
yes. In that case,
The interim prayer.
okay. In
You
that
get
case,
the
I will
instructions?
obtain the instructions.
Yes, yes.
On Monday or on DC, my lord, can I argue?
Yes, no problem.
The judgment which I am going to rely on, I am giving the compilation of it may be
Okay.
My lady, if
just
19th.
okay.
19 I shall be out of
Any date next week.
next week. Today is
17th, 19th, 20. 20?
17, my lord.
17, I'll be a little busy.
16.
Okay.
16 is Monday. No?
16 is Monday.
From DC I will. 16 is
Actually, 20 would be best.
20.
20 March.
20.
Yes. Learned Counsel for the petitioner, Mr. Goyal is present. Stop. Learned Counsel, Mr. V. Devnath appears for the respondents number 1 to 6 and submits that he will be filing his vakalatnama when? During the course of the day?
Yes.
During the course of the day. Stop. He has also prayed that he may be given some time to receive instructions regarding the hearing on the interim prayer. So accordingly, list on 23, 2026 for consideration of the interim prayer.
My lord, the judgment compilation may be kept in the file so that it can be.
My lady, if the medical certificate may be placed on record.
Not required.
Not
I am
record, it's
satisfied.
okay.
When the
They are not
counsel is-
objecting.
When counsel is saying, well, why I will doubt?
I'm the player.
No, same order. This
My
one.
apologies,
Yes,
yeah.
same
Same
order
order,
as
yeah.
that item.
Motion item number 1, ladyship.
Oh, this is for withdrawal, na?
Withdrawal and subsequently I file my
No, but you have not withdrawn, na? Withdrawal order is not there.
order is not there, ladyship.
Yes. The petitioner is allowed to withdraw the application at liberty to file afresh.
I've already filed my petition and mentioned memo is placed on record.
Let it come tomorrow.
Ladyship.
Yes.
Ladyship.